Good morning, this is your Kelso Report for Thursday, September 15th, and I'm your host, Clark Kelso. The intersection between science and law and policy is almost never clean or clear. The law at times seems incapable of accommodating even the simplest of scientific realities. Well, for example, ask a scientist how long a year is, and the answer you will get is 365.24237 days. Of course, that answer isn't much good from a public policy perspective, so our calendar approximates that answer by having 365 days for 3 years, and then 366 days for 1 year to make up most of the difference. Of course, we need to omit leap year every 100 years, except once every 400 years to deal with the rest of the decimals in the real answer. But neither the scientific nor the calendar answer works for the lawyers at the Board of Immigration Appeals. That's because Section 1101 of Title 8 provides that an alien who commits, quote, a crime of violence for which the term of imprisonment is at least 1 year, close quote, has committed an aggravated felony. Now, committing an aggravated felony has substantial negative consequences for immigration purposes. So the legal question arises, how long is 1 year for purposes of Section 1101? According to the board, the answer is 365 days, no more and no less. The issue arose because the petitioner was convicted of misdemeanor battery of a current or former significant other under California Penal Code Section 243E1 and was sentenced to a 365-day suspended sentence, which was served through the year 2000, which was a leap year. Under the board's interpretation, he had been convicted of an aggravated felony, which made him ineligible for cancellation of removal. The petitioner argued that because his 365-day sentence was completed during a leap year, which was 366 days long, his conviction did not qualify as an aggravated felony. Well, the Ninth Circuit affirmed the board's interpretation in yesterday's decision in Habibi v. Holder, noting that taking into account leap years would lead to somewhat inconsistent and arbitrary results, where two individuals, both of whom were sentenced to 365 days, would be treated differently, depending upon the fortuity of whether the term of imprisonment happened to include a leap year. The court acknowledged that there may be other circumstances when the law should take into account the leap year, but the interpretation of Section 1101 of Title 8 was not one of those contexts. As the court noted, quote, because taking the intricacies of astronomy into account would needlessly complicate this area of the law, we adopt the board's definition, close quote. Sometimes science is just too complicated for the lawyers. Well, our first one-liner here is in the habeas corpus area in Trigueros v. Adams. The Ninth Circuit struggled to read the tea leaves from the California Supreme Court when that court entered a simple one-line denial of a petition for a writ of habeas corpus, challenging a state court criminal conviction. Did the California Supreme Court deny the petition on the merits? Or did it deny the petition because the original filing in the Superior Court was untimely because of a 2.5-year delay from the conviction to the filing of that first habeas petition? If it was denied on the merits, then the subsequent federal habeas petition was filed within the applicable 1-year limitations period provided for by the Anti-Terrorism and Effective Death Penalty Act, because virtually all of the time between the conviction and the final state denial would have told the running of the federal limitations period. However, if the California Supreme Court denied the petition because it was untimely, well then the federal petition also would have been untimely because virtually none of the time spent at the state level would have resulted in tolling the federal period. Well, the Ninth Circuit ultimately held that because the California Supreme Court had ordered the state to submit an informal brief discussing both the timeliness issue and the merits, and then the court issued a one-line denial without identifying timeliness as the basis for the denial, the Ninth Circuit would conclude that the California Supreme Court's denial meant it found the petition was timely, but without merit. So the Ninth Circuit remanded the petition for further consideration by the District Court on the merits. I have to say that it would really help us all if the California Supreme Court would simply indicate whether its denial of these habeas petitions was on the merits, or was because of a procedural default, or was because of lack of timeliness. Forcing the Ninth Circuit to read the tea leaves or discern the color of the smoke coming from the California Supreme Court is no way to run a judicial system. Now, an evidence case. In People v. Morrison, the Second District rejected the defense contention that the prosecutor should have been barred under Evidence Code Section 352 from calling a rebuttal witness who directly contradicted defendant's testimony on a collateral matter, and from that arguing to the jury that the defendant's credibility on other matters should be rejected. As the court noted, the old, inflexible common law rule that a party could not call a second witness to contradict a prior witness on a collateral fact had been superseded by the enactment of Section 350 of the Evidence Code in 1965, which provides that all relevant evidence is admissible, and by Section 780, which provides that in determining the credibility of a witness, the trier of fact may consider the existence or non-existence of any fact testified to by him. The court held under Section 352 that the probative value of the rebuttal testimony was not outweighed by the risk of undue prejudice or the consumption of undue time. The defendant's conviction for attempted second-degree robbery was therefore affirmed. Now, in the area of criminal sentencing, in 3 separate decisions, the Ninth Circuit held that convictions for forcible rape, for willful infliction of corporal injury on a spouse, and for attempted sexual abuse of a child were all crimes of violence under the federal sentencing guidelines, thereby justifying substantial sentence enhancements. The rape case was United States v. Ruiz Apollonio. The injury on a spouse case was United States v. Ayala Nicanor. And the sexual abuse of a child case was United States v. Tafoya Montalongo. Now, I'm not going to review the details of these cases, because frankly I think the crimes' names speak for themselves about them being crimes of violence. We turn to ineffective assistance, a claim on appeal in People v. Orozco, where the 5th District considered its ineffective assistance of counsel argument in the defendant's appeal from his conviction for second-degree murder. The defendant admitted he stabbed the victim, but he asserted he did not intend to kill him. Thus, his mental state was the key element in the case. The defendant took the stand and on cross-examination admitted that stabbing someone can be dangerous to human life, testimony that was clearly damaging on the issue of his mental state. Faced with this problematic testimony, defense counsel asked the defendant whether he had ever seen anyone stabbed, which he admitted to, and whether any of those victims had died, to which the defendant answered no. Defense counsel might have reasoned that from this testimony he could argue the defendant did not intend to kill the victim when he stabbed him, because, after all, he had seen other people stabbed and they hadn't died. Because defense counsel might have had a reasonable tactical justification for eliciting the testimony that the defendant had seen other stabbings not resulting in death, the court held there was no basis for an ineffective assistance of counsel claim. The defense counsel's choice might not have been the best, but it was not an irrational choice, and there was a tactical basis for making it. Finally, in the area of ex post facto, in People v. Gray, the 2nd District reviewed defendant's conviction on 9 counts alleging continuous sexual abuse of 3 victims, lewd acts upon a 4th victim, and forcible rape of a 5th victim, all of whom were children at the time of the alleged offenses. He was sentenced to state prison for 136 years to life, in part based upon multiple applications of California's one-strike law, which provides that a defendant convicted of specified sex offenses committed against multiple victims in the same case shall be sentenced to 15 years to life. However, to invoke the one-strike law, section 667.61 of the Penal Code, the prosecution was required to prove beyond a reasonable doubt that Gray committed the 4 lewd act offenses on or after the statute's effective date of November 30, 1994. It was unclear from the record on most of the counts whether the date of all of the offenses was after the effective date. So the court had no choice under the ex post facto clause but to vacate and remand for resentencing without application of the one-strike law. And that's it for today's Kelso Report. Have a great day in the law.